Going on YouTube, RDAP Dan here, Federal Prison Time Consulting. Hope you guys are having a great week so far. Today we have Tom Root with us, who is from Legal Lisa Info, also happens to be an expert when it comes to the First Step Act and many other legal issues, which is why we have partnered up with Tom as our legal expert. So Tom, how are you doing today? Welcome back to the show.
Oh, thank you. I have to say it's with First Step, it's a lot like what they say about nuclear war: no winners, just survivors. I'm not an expert. I'm just a survivor of First Step. It's everyone's scratching his head wondering what it means.
Well, that's what we're going to talk about today, because as you probably get tons and tons of emails through core links and other correspondence, I as well have been receiving quite a few emails through core links, families that have been reaching out, wanting to know how the First Step is going to apply, when it's going to go in effect. Is there going to be any real benefit? Just kind of a little bit of everything. And there's been so little information actually released that anybody can draw any type of conclusions from. We're hoping you can maybe shed some light today, Tom.
Well, I can at least tell you what hasn't been decided yet. Okay, so let's go ahead. What would you like to talk about first?
I know everybody can't wait to find out how much good time they're going to get and how these programs are going to work, from the risk assessment for getting the 10 to 15 days towards pre-release credits on the tail end of their sentence, whether it be halfway house or home confinement. But I know you said there's also some pretty interesting news around elderly being released, the compassionate release. So I was hoping you could tell us a little bit about how that's going to look first.
Okay, let's talk about elderly first. Back in 2008, the Second Chance Act authorized the Elderly Offender Home Detention Program. Essentially, it said if you were old and had done 2/3 of your sentence and at least 10 years and were nonviolent and a number of other factors, you could get sent to home detention for the rest of your sentence. It was so restrictive that I think 8 inmates in the entire system qualified for it. I remember one case I worked on where this guy was 79 years old. He had been a stroke victim. He had had a heart attack and cancer, and he was people were pushing him around the compound in a wheelchair. He couldn't get it because 50 years before, as a brash 18-year-old, he had robbed a liquor store. That was violence, and that excluded him. Because of that, in the First Step Act, Congress changed things around on elderly offender. Now, at that point, it was a pilot program being done in one institution. Now it's being done in every institution. And you don't have to do 10 years anymore. If you're 65 years old or 60 years old now, they dropped it 5 years. If you're 60 years old, if you've done 2/3 of your sentence, if you're nonviolent, you can get sent home for the balance of your term. Now, that's nice because up to now, home detention was, should say home confinement. Home confinement was only available for the final 10% of your sentence, not to exceed 6 months. That provision is still in the law, but elderly offenders in a different part of the law, and says, notwithstanding that, if you go home on this program, you can be there for from 67% of your sentence right up to 85% when you get released. I think I've seen the numbers, and I think there's something like 210 who have gone so far on elderly offender. Some places I've had guys tell me they've requested it, and the case managers say, we don't know what you're talking about. Other places, I had a woman tell me that they actually came through and tapped people on the shoulder and said, you're eligible, come on, let's get the paperwork going. So most common question I get on elderly offender, these guys say, well, how do you calculate 2/3? Is that 2/3 of your sentence or 2/3 of that release date they give you? Well, I tell them you can't double count. I mean, your release date is set on as 85% of your full term. You don't get to do 66% of your 85%. You got to do the full 66. And say the way it works is once you've done 2/3 of your whole sentence, then you get to do from 67% to 85% at home, and at 85% you get released.
So you're still serving the 85%. You're just doing a portion of it at home or home confinement or halfway house.
Well, no, it's no halfway house. It's home confinement. The only exception in the program is that they will consider a nursing home or assisted living facility as home for that purpose.
Gotcha.
So, so that's the elderly offender, and I have a
Now,
lot of
is that the same as compassionate?
no, no, completely different.
Okay.
An elderly offender, you don't have to be sick; you just have to be old.
So
It's
let's talk about compassionate then. Does compassionate only apply to the health and well-being of the inmate, or could it also have something to do with you've got a dying parent, a child, something going on there, some crazy circumstances through the first step?
well, once again, compassionate release was always in the statute. 18 USC section 3582 C1 has always let the Bureau send you home, or at least recommend you go home for extraordinary and compelling reasons. And that's all the statute says, extraordinary and compelling. It doesn't say a word about being sick. But over the years, the Bureau developed its own program statement saying that extraordinary and compelling meant that you better be dying. Well, a few years ago, the Inspector General at the Department of Justice started looking at compassionate release, and Congress started looking at it and demanded numbers from the BOP and discovered a few things. First, the BOP was sending very few people home. I think for a 3-year period, it was something like 51 people were eligible. In fact, sadly, more people died waiting for compassionate release than actually got it. And that was the other thing that had Congress all fired up, that people would apply and they were waiting 140, 150 days for a decision, and they were falling over dead, because back then, if you weren't within 12 months of death, they weren't going to listen to you. The problem was that the only way to get compassionate release was if the director of the Bureau of Prisons recommended you get it to the judge. So the Bureau of Prisons was the gatekeeper, and nobody was able to get past the Bureau of Prisons. If you didn't like it, you couldn't appeal. So Congress made a change in compassionate release, and it was really only one change in there, but that change that makes all the difference. Now the rule is that if you ask the director of the Bureau of Prisons, or actually you go to the warden first, you ask the warden for compassionate release and you get turned down, you have to go through the remedy program. And once you go through the remedy process at the Bureau of Prisons, you can ask your judge yourself for compassionate release. What's even better is if you apply to the warden and the warden does nothing for 30 days, you can go directly to court. I've already told some guys, who file and they say, well, how fast do you think the warden will turn it down? And I said, well, for your benefit, I hope the warden doesn't even touch it. Just let it sit. I had one guy who told me he actually said to the warden, he saw him on Mainline and said, hey, if you're going to turn that down, do me a favor, just don't do anything. Warden was a decent guy and he just didn't do anything. So on the 31st day, the guy went to court. But here's the interesting twist on it, that compassionate release does not have to be for sickness. The Bureau's always said it, but it doesn't have to be. There were a few cases, 20, 30 years ago. I know of one where a BOP staff guy in Unicor fell over of a heart attack and stopped breathing, and an inmate gave him CPR and mouth to mouth until they saved him. And as a result, the warden recommended him for compassionate release, saying what the guy did was extraordinary and compelling. That didn't happen much. Like I say, I only know of one time it occurred. But what some people have been doing here, and I think I wrote a column about this last January, that compassionate release now is a real sleeper, because all you have to do is convince the judge that you have an extraordinary and compelling reason, and you can go.
So this is not just a recommendation from the judge. If the judge signs that, that's...
Yeah, the judge does it.
Okay.
And whether or not the Bureau of Prisons recommends it, it's the judge can do it. I know there's a case going on in the Western District of New York where the judge granted compassionate release to a guy because the guy had stacked 924 charges. If you know what I mean, he robbed a bank with a gun. Next day, he robbed the bank with a gun. The day after that, robbed another bank with a gun. Well, under the old regime, he got like 55 months for the bank job and then got 84 months because he pulled the gun.
Each time.
Well, no. The first time he got 84 months. The second time he got 300 months because it was considered a subsequent 924. And the third time he got 300 months. So all of a sudden you have a guy doing like 60, 70 years. Well, Congress never meant that. There's a provision in 924 saying that it's got to be consecutive. And if a second 924 happens, it's got to be consecutive and 25 years. Well, Congress meant consecutive after you were convicted of the first one, but Congress didn't say that. So over the years, the U.S. attorneys have stacked them up and convinced the courts. The Supreme Court even said, yeah, I'm afraid that's what it says, that you stack them and you go 25 years on each subsequent 924. Well, First Step Act fixed that. Now 924 says that you get the 25 years subsequent only if you've already been convicted of a 924 and you're stupid enough to go do one again.
Now, is that just going forward or is that retro back?
That's the problem. It's just going forward. As with just about every change in sentencing in the First Step Act, it wasn't retroactive. The only thing in First Step that was retroactive was the retroactivity on the Fair Sentencing Act of 2010, the crack law. If you remember back then, Fair Sentencing Act passed, cutting crack from 100 to 1 to 18 to 1, but Congress didn't make it retroactive because they couldn't get some of the knuckle draggers to go along with it unless they said non-retroactive. Now, a lot of guys got screwed by that. 9 years later, Congress fixes it. I've been telling people that you can't take it to the bank, but I suspect that in 4 or 5 years, there'll be another sentencing reform or prison reform bill. And at that time, they'll make the 924 stacking and the change to the 841, the drug maximums. I think they'll make them retroactive then too. But back to the issue, the guy who went to the judge in Western District of New York had stacked 924s. If the stacked 924s hadn't been 25 years apiece, he'd already done like 30 years. And the judge says, it's not extraordinary and compelling solely because he has the stacked sentences, but he has a great prison record. He's been there a long time. He's old and infirm. And all of that, including this fact that the sentences are stacked and he couldn't get those today, I'm going to let him go. And he did. There are a lot of guys in there trying to make the extraordinary and compelling argument that in their case, something about the sentences, their prison record, all this is extraordinary and compelling. And frankly, it's pretty much however the judge feels that day.
So with this First Step Act, Tom, and you've given quite a bit of information so far on it, for those of you that have loved ones that are spending potentially a long period of time in federal prison, I know most of our content is normally about first-time nonviolent offenders serving somewhat of a 10-year or lesser sentence. So I know there are other individuals out there that do need what you're talking about as well, Tom. But the majority of the people that are here today are probably, let's kind of segue into this now, because I'm curious to know this because of how often my email is blowing up. Let's talk a little bit about how the First Step Act is potentially going to help people with the shorter sentences. There's rumor of 10 days per pre-release time, 15 days of pre-release time. People that may have priors that are not first-time nonviolent offenders. How does this work out for them, and when can people start seeing some resource from this? Okay,
let's talk first about what it is. Congress was all about stopping recidivism. They wanted the First Step Act to take a stab at keeping people from coming back. What they decided was that they needed to encourage inmates to take programs that were evidence-based to reduce recidivism. Now, what is that? Nobody knows for sure yet, but there are all sorts of programs in prison, everything from GED, if you don't have your high school diploma, to drug classes, various different kinds of offender classes, And positions like Unicor, a lot of vocational training, even adult continuing education classes. A guy who took a Shakespeare course. But
So what was all of this that we've been waiting and waiting and waiting for, the middle of July to get this release from First Step on updating information for the risk assessment tool? Weren't they supposed to start telling us what classes are going to be implemented?
not if you read the fine print. Fine print said, this is as of December 21st last year, that the first thing that had to happen was the Attorney General had to come up with a system for assessing how likely each inmate was to be a recidivist, to repeat offend. And the Attorney General got 210 days to do that. Well, that happened to be July 19th, and that's why July 19th was such a big day, one of the reasons. Once the risk assessment tool was released, the Bureau of Prisons then had 6 months to develop the list of courses that are going to be evidence-based to reduce recidivism. Once all that happens, and that would, by my calculation, that puts us like about Martin Luther King Day in January. When all that happens, then inmates over the next 2 years will see all of this phased in, and they'll be able to take courses that are evidence-based to reduce recidivism. Now, let's assume for a minute we know what that means.
Do we even know what the risk assessment tools are at this point? Do we know, is that defined, or is it just going to take all of the inner city, the outer city Black folk and tell them none of them qualify because they live in a dangerous area? I know that's a big fear.
No, actually, it did not turn out that way. We do have an idea because last Friday, the Department of Justice released the proposed risk assessment tool. It's not final. It won't be final until about Thanksgiving. There's a notice and comment period, and people can throw their ideas in, but we have a real good idea of what it looks like here. There are two kinds of factors. There are the static factors, the things you can't change, like have you ever committed a violent crime? You can't unring that bell.
Right.
But there are also dynamic factors that will change. There are 17 different factors, and you get scored on them according to this matrix. Your best score, if you are the mildest Casper milk toast who ever came down the road, and you're 65 years old and you've just committed a crime for the first time, and it's something really soft, you could score as low as a -50. If you're a hardened criminal, the kind of person who's probably not listening to this YouTube cast, you could get up to 100. And the way they're going to split it is if your score is from -50 to 10, you are considered to be in a minimum risk category. If you are it's like 10 to 33, you're low risk. If you're 33 to 45, medium. Above 45, you are in the high risk category. Once they've got everyone figured out the risk of being a recidivist, then you can start taking courses. Taking the courses brings down your score. The older you get brings down your score. The longer you go without disciplinary problems in prison brings down your score. All those things work.
So what distinguishes whether it's going to be 10 days or 15 days? And if you're qualifying for that, and I know you were telling me a little earlier that education versus a job or a program might work different based on how they give that out. But if you do qualify for it, is the BOP forced to enforce it?
Yeah, the way the statute's written, it's simple. If you're taking one of those courses, you get 10 days of earned time credit, or 15 days, and I'll get to the difference in a minute, for every month you take the course if you successfully complete the course. So I gave an example of somebody, let's say you go in and you don't have your GED. You're in GED for 6 months and you finally get your GED and you finish it. At that point, if say you're a medium risk, you're going to suddenly get credit for 60 days, 10 days a month times 6 months.
Okay.
I don't know why it was written this way, but if you're a high risk and if you're a medium risk of recidivism, you will get 10 days a month for every month you're taking a course you successfully complete. If you're low or minimum, which you could argue are the people who need it less, you get more credit. So let's say we got a guy who's going in for the first time for securities fraud, and he gets 3 years, 36 months. So you get there and it takes you 2 months to get through admission orientation, you get a job, you start taking classes. Well, if you take a class for 12 months and you complete it, or you take a succession of classes and you complete them, then you're going to get 12 months times 15 days, which comes what, like 180 days, something like that, about 180 days earn time credit.
What if you're programming and taking a class that qualifies at the same time? I imagine you're not going to double dip on this. It's going to be a max, I'm assuming.
Yeah, there's nothing in the statute that talks about it. And the fact that it says you will get 15 days, I don't think there's any wiggle room. You're going to get a max of 15 days no matter how many classes you take.
So don't run out there, guys, and take 30 classes at the same time thinking you're gonna capitalize on these, maximizing the days.
Yeah, it's like my wife says, it's a marathon, not a sprint. So if you've got 10 classes you can take and each one lasts 2 months, then space them out, finish the one, start the next. I mean,
so what happens if, let's say, you accumulate 180 days?
Okay.
6 months.
So you got your 180 days in the bank after the first year, and you don't do any more. What can you do with them? Well, the statute says there are 3 things the BOP can do. First is that for the first 365 days you accumulate, you can take that off the end of your sentence. You can get out earlier, sort of like RDAP without the drug program. So you can get a year off. Now, it's not a freebie, because what the statute says is that year gets added to supervised release. So if you got 3 years in and 3 years of supervised release, then you might be able to do 2 years in and 4 years of supervised release. Supervised release is no fun, but still, your worst day on supervised release is probably better than your best day inside.
So my understanding of these pre-release credits is they were towards halfway house or home confinement. Are you saying it's towards actual?
Well, there are 3 things. The first thing is, let's say we got a guy who's in for 10 years, and he works hard on this, and he gets 15 days a month. That'd be times 120 months. So he ends up with like 1,800 days. He can use 365 days to cut his stay from 10 years to 9 years. Beyond that, he can use that remaining time toward home confinement or halfway house. Now, it's up to the BOP which one. I tend to think the BOP is going to be forced. I think the BOP will be forced to give everybody time off first, because that costs them the least. Second thing they'll do is give you home confinement, because that costs them a whole lot less than halfway house. And then third, you get halfway house. But I really think what's going to happen is, as long as you got a home to go to that the probation officer says is all right, you're going to get home confinement. So our guy with the 1,800 months or 1,800 extra days might get a year off, so he's down to 9 years, and he's still got something like 1,400 days unused. He can use all those for home confinement. I did the math, and if you start taking classes immediately, you could conceivably do 56% of your stated sentence. So mathematically, a guy with 10 years could end up doing like 5.5 years. It's never going to be perfect like that, because first, you're not going to be able to start the class right away.
You're dealing with the BOP.
Yeah, you're dealing with the BOP. But it has the potential of substantially cutting your stay.
So how is it going to, so I also read a lot, and it's so teetering back and forth. You really have to reflect on what you read on one page and kind of reference it back on the next page. But talking about the safety valve, if you've got criminal history points and you're no longer qualified for safety valve because of criminal history points, isn't it supposed to also assist with allowing people to qualify to get under minimum mandatories that have criminal history points?
You're talking about the portion of the First Step Act that actually changed.
Yep.
It's Title 18 U.S. Code 3553F, I think is the...
Tom Root, the savant, guys, just in case.
Oh, hey, you work with the statute every day and you know it, but I have to look up.
That was actually a question by Nick Schlafman, who's in the room. So he's answering your question now, Nick. So Nick's exact question, Tom, was, I have 2 criminal history points for a nonviolent crime. Am I eligible for safety valve now? Clearly, he's got a minimum mandatory, which is probably why he's asking.
Yeah. Yes, he is. Now that, like everything else, was not retroactive, but Nick doesn't have that problem. And because as long as he's getting sentenced after last December, and it sounds like he is, yeah, he qualifies for safety valve.
So he does qualify for safety valve.
Yeah.
Even with the criminal history.
Yeah. Now,
as long as he's sentenced after.
One proviso, what was he convicted of?
Nick, can you answer that question if you're still watching? If you can, what's the crime you pled guilty to? And while Nick's answering, we got another question here while we're waiting for Nick to respond. So I got out in March. Does the Prison Reform Act go towards my probation since I'm home, but it was passed in January when I was incarcerated?
No, sadly, it deals only with incarceration. The courts have been consistent over the years saying they're 2 different animals, supervised release and imprisonment. And I've had a lot of guys who have complained because they've left a lot of time on the table because, say a change in the law, the guy should have gotten out in July of 2018. And of course, it only became effective now. So he gets released on July 19, 2019. He says, well, I had like 12 months of time I should have gotten that I didn't. So does that cut my supervised release? The answer is no. Of course, the good news is supervised release is a real loosey-goosey thing. And anybody is entitled after 1 year to petition the judge to terminate them early. So
mentioning of that, guys, that's one of the reasons why we have partnered up with Mr. Root, is because of his legal expertise. For those of you that don't know, Tom used to be an attorney. Tom found himself in a bind, ended up going to federal prison, saw it from both sides, and now is much on the prison reform side of doing what we can do to help people understand what their options are. So Tom does all of the actual writing for just about all of our motions, early termination, getting additional halfway house, where we're writing letters to senators and judges. So if any of you that have any questions or you'd like to do a consult, if you look at the top of this post and in the description of this video, we actually have a link in here. I'll go ahead and post it again, where if you want to book a consultation for any of these questions, it's for an hour. Let's give you an hour consultation. Here you go. And it's also in the description. So yes, Tom is the man. And Tom, the answer on the other question for what kind of crime did he have, it was for sale of marijuana. Such a horrible crime.
Good for you.
Guys should not be allowed in our room with such a heinous crime.
Well, his mistake was not doing it in Colorado, but okay, good, because I've had guys who come in and say, well, I've got this offense and a mandatory minimum and on and on and on. Can I use safety valve? I'll say, sure. And then they'll say, oh, good, it's a 2-year minimum. I said, you mean for identity theft? And they say, yeah. And I say, no, I'm sorry, safety valve is only for drugs. But Nick had the right answer. So yes, he is entitled to use the safety valve. Now, there are a lot of limitations in the safety valve, which I'm sure Nick knows. You better not have had a gun. Nobody got hurt. You bear your soul to the government, and you don't have to give up anybody else beyond the crime. I saw a case once where this guy was denied the safety valve because he told him everything about what he did, but they all wanted to know about his cousin who had his own business going, and this guy wouldn't talk. So the judge denied him the safety valve, got it reversed on appeal. The appeal said, no, you got to talk about what you did. You don't have to cooperate with them and talk about somebody else.
So the correction on Nick, just to be clear here, I think the sale, the marijuana was his prior charge. That's what gave him a criminal history, why he didn't qualify for safety valve. The new charge looks like is he just said, I'm working to get safety valve for conspiracy to distribute cocaine. So I assume he would still be okay.
Good for you, Nick. Yep, you're still okay. And I don't mean good that you violated 21 U.S.C. 846, but hey,
So how does he hold his attorney accountable in this situation? Because my question to Nick is, why are you asking? I'm glad you're asking that in the room because it's a great community question, but how come his attorney is not educating him on this? And is it likely that the government and the prosecutors are trying to not allow him to have safety valve based on old precedents, that they don't understand how this new law is working?
It's quite possible that they're not aware, although the U.S. Attorney's Office has a pretty good training program. I got to believe they are. There is one twist in the safety valve. If he was a leader organizer of this, he might have a problem qualifying for it. But I take it no one told him he didn't qualify for any reason other than he had too many points.
Is that the case, Nick? Were you a leader organizer in your crime, managerial role, anything of that wording? Chime in when you get a moment there. Let's see if we have it in. Guys, if you got questions for Tom, now's the time to ask, or else you're gonna have to book a consultation and send us $200 for the consultation. So we've got Tom's time, right? I apologize on the video the other day. Somebody sent me a message and said, "You realize you called Tom Tim like 3 times." Don't know how Tim came out of my mouth, but I went back and watched the video, and sure enough, the word Tim Root came out of my mouth 3 times in a row. So Tom Root, to clarify. Tom, some of these, so when it can reinvent the safety valve, is only talking about priors. If you have a managerial role or aggravated identity theft, things like that, you're still going to have, there's nothing you can do to get underneath that minimum mandatory in that situation. That's not going to give you safety valve.
Yeah, because I'm not the savant some people say I am, I'm pulling it up here. Okay, if Nick did not use violence or credible threats or possess a gun or other dangerous weapon, he's okay. If nobody got hurt or killed, he's okay. If he wasn't an organizer, leader, manager, or supervisor of others, he's okay. And then he has to, of course, truthfully provide to the government information and evidence concerning the offense or offenses that were part of his course of conduct. If he's done all that, then he's okay, provided he doesn't have more than 4 prior criminal history points. Or a prior 3-point offense is determined under the guidelines. Maybe that's where he ran into it. Maybe his prior marijuana was a 3-point offense under the guidelines.
Well, he did just say his attorney told him that he's all good. He was just making sure from a different source.
Oh, okay.
So he's basically validating what his attorney was telling us. Jessica Kent, I just saw you chimed in the room. Jessica Kent, thank you. She appreciates the content. And Fresco. So Michael Fresco has joined us, who is one of our clients who just got released. He's actually spending time in the federal halfway house right now. So welcome home, Mike. Many of you may have remembered Mike's blog. Mike was the police officer in Miami who was transporting guns through security to hand them off. And he ended up going to prison. He qualified, did RDAP, got his time off, and he's home. How much time did you end up serving, Mike, total and how much time were you sentenced to? Mike was one of our original clients about 2 years back. Jamie Mosley, can you explain 440? Not sure if that's the correct number. Has to do with the 10% and the 6 months. I think they might be referring to.
I think they're referring to 18 USC 3624 C1, which is halfway. It's a home confinement maximum.
That's what it sounds like, 10%.
Yeah, and people have asked, well, how can I get all this time for elderly offender? Or how can I just saw a judge send a guy on compassionate release. Instead of releasing him outright, he sent him home for the remainder of his sentence. The guy was a bank robber. In fact, the guy was a frequent flyer. It was like his 11th bank robbery conviction. Most of them had been state. But the way it works is, right now, there are 3 ways to get to home confinement. The first is the traditional way, which is under 3624 C1, which is you're allowed to have 10% of your final sentence or 10% of your sentence not to exceed 6 months in home confinement. That's if you do nothing. If you sit on your bunk the whole time you're in, you still get that. And the First Step Act urges the BOP to give low risk and minimum risk people, and notice it said risk and not security. We're talking about this new risk assessment system, to give them maximum home confinement. I've never understood why the Bureau doesn't use it more than it does, because it's cheap. It's really cheap for them. It costs like $7-8 a day by
So
their counting.
is the max still 10% of your sentence or 6 months?
Yes, but there are exceptions. There's a different part of 3624 that sets up all this earn time credit. And that lets the BOP give you as much home confinement as you can possibly have. And the elderly offender program is not even in Title 18, it's in Title 34. And in fact, for those of you who like the numbers, it's 34 US Code 60541 G5.
Let's write that down. What is it again?
It's 34 USC 60541 parentheses G parentheses 5.
He's going faster than I can type, guys. Well, when we're done, I'll have Tom, if you could email me some of these pertinent codes, and what I'll do is I'll add them to the description of the video after the fact.
Sure, I will do that. But
Jamie says, yes, that's what she was talking about.
Yeah. And that if you're an elderly offender, then under Title 34, BOP can send you there for however long 67% to 85% of your sentence is. I mean, for some guys, it may only be a year. If you get somebody who had a 30-year sentence and they get to 20 years, they could do 4 or 5 years at home.
So technically right now, for let's say individuals that are getting 7, 8, 9, 10, 11 months halfway house, could they technically do all of that at home confinement now?
Not today.
Well, no, because they don't have the earned time credits yet,
Don't
correct?
have earned time credits, yeah. Okay. They're still limited. And that's the problem, because a lot of your clients, well, it's a nice problem. A lot of your clients have 30-month sentences, 24-month sentences. And I'll never forget seeing it happen. A guy came in and he was sitting on his bunk just staring at his hands because he had gotten 18 months for having an old unusable 22 up in the attic, and the guy had a felony for which he got in probation back in the 90s. And he's sitting there feeling sorry for himself, and some guy who was finishing his 30-year bit, he was down to his final 5 years. I was sitting there talking to him, and he said, how much time do you have? And the guy says, 18 months to do. And he looked at him and said, man, you're short. And that guy carried that the whole time he was there. And he said to me toward the end, I felt so bad sitting there feeling sorry for myself. And this guy hears I have 18 months, and all I can say is, man, you're short. But,
I think all of us that have a shorter sentence probably had that awakening in prison, including myself. You go in there and you feel like whatever your sentence is, 40 months, 60 months, 80 months, you feel like it's the end of the world until you met somebody that has already been down 15 or 20 years and they still have 10 to 15 years to go. So it's to say the least, it's a very humbling experience entering into the federal prison system with a shorter sentence.
Yeah. I had a guy tell me this story once about a camp. He had worked his way down from medium and had just gotten to camp, and I was talking to him on the phone, and I said, so how is it? And he said, let me tell you, there are two kinds of people at a camp. The people who came here off the street, all they can do is bitch. He said, but you can tell the guys that came down from mediums and lows to camp because we're just kicking back, loving it.
That's the truth.
Yep.
Tom, what's the best way for people to contact you? Go to your website?
Yeah, that would be good. They can also contact me through you.
Well, obviously through me, guys. Tom's going to be showcased on our website real soon. He finally got us a beautiful mugshot. I mean, not a mugshot, mugshot, headshot. Got us a beautiful headshot to put on the site with a lot of what Tom's going to be doing with us. But I just posted his website in the room, and he also has a newsletter that goes out. What is it? Every Monday, correct?
Yeah, actually it goes out every Sunday night, 10 o'clock, but it's dated for Monday. To anybody in the system. I've got 7,800 odd subscribers. Doesn't cost anything, but the catch is you got to read it in core links. If you're on the outside, or if your family wants to read it, they can go to the website and they can click and see exactly what the newsletter said.
So for those of you that have family members or friends that are in prison, and as we know, when you're in prison, you get all kinds of misinformation from inmate.com or a rumor spread, some bill that was introduced or that was proposed, but's never going to pass. Have your inmates reach out, your loved ones reach out and have them add Tom on core links. And every Monday morning when they check their email, there's a beautiful newsletter in there with what's going on with the updated laws, what bills are passing, prison reform, a little bit of everything. And I used to read these while I was in prison and found them quite educational. Josie Crow, how are you? Welcome, welcome. William Sutton, glad you could join us. Yeah, we have a nice following here today, guys. And I really hope you guys take this information and maybe watch this video a couple of times. And as the first step rolls out more and more, so we've got another 6 months now before. Here's a question I have. We've got 6 months before they need to implement. Is it before they need to implement the programs or before they need to outline and explain what the programs are?
They've got to start implementing in 6 months. So they've got to have, my read of the statute is they've got to have the programs available, or at least identify them. You see, a lot of the programs that are there now will be identified as qualified programs. I've had people asking all along is, well, hey, will working in Unicor qualify me for credits? Will GED qualify for credits? If I take college courses, and college courses are coming back, we should talk about that in a minute. If I take college courses, will that qualify? Well, we don't know, but this new risk assessment program, which they call Pattern, it's an acronym. Pattern has a few hints, I think. As I said, there are 17 different criteria that they'll give you points on to come up with your pattern score. And one of them happens to be, are you working in Unicor? Well, that suggests to me that they consider Unicor a positive, and probably a job in Unicor, besides paying you the big bucks, at least as far as prison system goes. What'd you say, Dan? $40 a month? Maybe?
$40 a month, maybe. And I mean, I'm sure there's the number ones in Unicor making maybe close to 100, but do you think that's because Unicor is a prison industry career where most of the jobs in Unicor are more or less free labor for the prison to create their uniforms, create furniture? So is that why they would incentivize people to do that program?
No, I actually don't ascribe any sinister motive to them. I think that they believe that if you have to get up and go to a factory job and be there on time and do repetitive tasks and do them according to instructions, that probably that helps break the cycle of crime. You get out and the idea of a factory job isn't so bad. And you think, I can go do the same thing in Unicor, but I'm not going to get patted down by anybody. My supervisor won't have handcuffs stuck in his belt, and I get paid $15-20 an hour. So I think they probably really believe that Unicor is a benefit, and people in Unicor are less likely to go out and commit new crimes.
William, go ahead. And William just asked, sentenced to 27 months. Do you think I qualify for first step? Give me a little more information on what you were sentenced, priors, some of the factors that Tom would need to run some numbers on. Tom, another question I have on first step. So right now there's several prisons with the zero programs. I talked to many of my inmates in camps that there's zero programs to take. And some of them even have told me that the reason why a lot of these programs were shut down is because some of the facilitators, their jobs were to teach the programs, and they've been pulled out to actually become BOP COs, correctional officers. So they went from being a teacher to a correctional officer. How are they going to be given a larger budget to implement this? I mean, is it going to be is every prison going to offer this, or is it going to be one prison might get it, then next month another prison might get it? Is it going to be staggered?
Talking money here. Yeah, first, what you're talking about, the librarians and the teachers and all being nurses being brought in as COs, BOP calls it augmentation. When they're shorthanded, these people get called in, and it's been a big problem for them. There's nothing in the First Step Act that solves the CO shortage problem, but everybody has to have the programming. And one thing the Department of Justice announced last Friday is that they have found all $75 million needed for the first year of implementation of First Step. So First Step's funded. Problem is, First Step doesn't solve the CO problem. On the other hand, if the program's offered and the teacher it gets extended from, let's say it's a 2-month program, but because the teacher is missing so much for CO, it becomes a 4-month program. Do the math, guys. That means you're going to get 40 days or 60 days credit for it because you've done it over 4 months instead of over 2. So it's not all bad. But I think you are going to see more of the augmentation problem hurting programs in the higher level joints where they need many more COs per inmate. I don't think you're going to see it that much in the camps. And, I have yet to run into a place that doesn't have ACE programs, and maybe ACE, that's adult continuing education. I mentioned Shakespeare earlier. A guy took Shakespeare, they took electronics, the
culinary arts.
Yeah. So I just read something from a guy who said he had taken feline and canine behavior. But are those going to count? I don't know. Because if they start counting ACE classes, then there's something for everybody. But there has to be a GED course everywhere you go. So you figure the GED's there. Just about everybody has a non-residential drug program.
Right.
And the places that have had some fancy programs like Milan for years has had this, I can't even think of what they call it, but it's kind of a spiritual life program. And I knew guys who were going there and taking it. It was like 9-12 months. You had your own unit, the whole thing. And I said, okay, what do you get for it? And the answer was nothing. I think those courses will start to count now. So
we shall see. And somebody just asked a question and what you were referencing earlier on when we spoke on the phone. I got 2 questions. Let me read the first question here from William Sutton. Sentenced to 27 months for pled guilty to wire fraud, no criminal history. That should be a no-brainer for first step, correct?
Yeah, I mean, it's simple. I'm confident that under pattern, he's going to come out as a minimal risk of recidivism.
So that would give him potentially 15 days instead of 10.
Yeah. Now,
Okay.
I have to ask, though, is William Sutton?
Yes.
Like Willie Sutton? I sort of figured it'd be bank robbery. You don't remember Willie Sutton?
Yeah, back in the day, the old bank robber. Yeah.
Yeah, he's the guy who famously said he robbed banks because that's where the money is.
That's where not anymore.
Yeah.
And then we have a question. Actually, this question is from Freshco, my client, who's now out. He says, to date, I have not received my additional good time. Is that due to RDAP making me ineligible for receiving it? That's a rumor I heard. That's exactly what you had told me you heard today, Tom.
I have heard that now for the past few weeks. And the first guy I heard it from is home on home confinement. And he called me up and said, what can I do about this? They're not going to let me off home confinement at my new date. He told me I got a year off from RDAP and I should just consider my extra 7 days as part of the year. And I said, I couldn't believe it. I said, I'm sure that whoever told you that, your RC counselor didn't know what he was talking about. But since that time, I have no fewer than 12 emails from all around the country, people telling me the same thing, that those who have completed RDAP aren't getting the 7 days. And one guy, I got an email last night, and this family member angrily wanted me to explain why they were doing that. All I could say is, I have no explanation. It boggles the mind. And he said, well, what can we do about it? He said, probably nothing, because you've got to go through administrative remedies, which takes a full 6 months. Then you'd have to sue under habeas corpus, and by then it's done.
And what are you really going to get? An apology? Maybe, yeah. Probably not.
Yeah, because by then, the horse has left the barn.
I think this question was answered already, but it was asked again by Todd Johnson. Todd must have missed that portion. Will this help supervised release? I hit 1 year, 6/20/2019. Great PO, but she wants me to wait till December. Is there any way I need to move to obtain my DRIV, driver's license, maybe? From what you said, it's not going to affect getting off supervised release any sooner as of now.
I'm afraid no effect.
No effect.
I've actually had guys who are back on supervised release violations saying, well, I should have gotten off earlier. So can I take the credit I should have gotten for my sentence for the 7 days and apply it to the supervised release violation? The answer is no.
So what do you recommend individuals when they're filing these remedies? Is there a clear-cut pattern to how they should file the remedies from the inside, or are they just relying on other inmates to show them how to do it? If you have somebody for anything, let's say like the client you're helping me with right now, that was inaccurately denied for RDAP for reasons that shouldn't be reasons, and he's got to go through this remedy process and filling out these forms. Is there a right way and a wrong way to do these forms? I mean, obviously do them in the right order, but is there a benefit to having assistance with filling out these forms?
Well, you can probably get assistance from the people inside. You can also get assistance from outside people. But let me say first that, I'm not a cynic, because I told you that I didn't think they were giving credit for Unicor because they like the free labor. So that marks me as being a Pollyanna. But having said that, I got to tell you that the administrative remedy process exists for one reason, and that is to frustrate you to the point that you won't get to the end properly and go ahead with a lawsuit of some kind. It is the BOP takes the view that once they've decided something, that's it. I have no doubt that the one we talked about today, we're going to file the thing properly and on time, and he'll work his way all the way up through the BP-11 to the central office in Washington, and he'll get denied, or the central office will do nothing, which is more often what happens.
Just not respond?
Yeah, not respond. And the rules say that if they don't respond within their time, which is 60 days if they take their mandatory extension, then you can sue. But that's okay. They figure you're going to sue or not sue regardless. We made you do all the work. So,
right.
Yeah. Having said all that, I will tell you that if you're filling them out, you have to be careful to make all of your claims, because if let's say you get to the regional office and some guy looks over your shoulder in the library and says, you should have raised this as well. And you say, okay. And so you toss it in the regional remedy. That will be denied because you didn't raise it in the BP-9. What's worse is you go all the way through, and then let's say you got a lot of money, so you hire a lawyer, a real hot habeas corpus guy, and he says, oh, well, we're going to make this claim and that claim, some other claim. If you didn't make them in the administrative remedies, then you didn't exhaust them, and you're not allowed to bring them in habeas corpus. You are limited to what you can type on the front page of that remedy form, which is only about a half page long, and one attached page. So you gotta, the best written ones I've seen, guys have gone through multiple drafts, and you get it done and you get it.
So don't rush yourself through these forms in the heat of the moment when you're denied. Think about it, take your notepad out, write down your reasons, really come up with a plan of how you're going to follow through this. So definitely preparation for how you're going to prepare with this. And I was asking that because we've had a few clients now that have reached out to us that asked for that assistance to work with them filing their in-house remedies, not filing them, but helping them prep what needs to go into it so they don't make these fatal mistakes down the road. So I think that's pretty good advice there, Tom.
And if you're tempted to cite cases, don't bother. Just say, this violates my due process. Leave the legal argument to later. That way you've raised the issue and you can go on. But it's truly an art form.
Okay. All right. Does anybody have any last minute questions for Tom before we go ahead and wrap this up? We're at about 55 minutes right now. So we want to keep it short enough so somebody later on might actually look at an hour-long video. My husband is in the same situation as Roy Hobbs, still have not received additional good time and have heard the same rumor. She's referring to my client that completed RDAP. I'm going to be looking into this as well. I have probably right now somewhere around 30 individuals that are all in RDAP. So I will do a mass reach out to all of them and see how much of this, see if any, I just want to find somebody that's completed RDAP that's gotten the time credit. That would kind of answer some of these questions.
Well, there's a second problem with this too. And that is a lot of people who are not even going to take RDAP have not had their 7 days time computed yet. And if you look on the BOP site, they're still showing the old dates.
Right.
And what I have found on that, which is, it's not the most solid information, but it makes sense, is that the BOP says that they are calculating them as fast as they can. They're doing each one manually, doing about 5,000 a month, and people are just going to have to wait. So obviously, if your out date is 2030, then waiting a few months doesn't much matter.
It's the people that are getting out now. Hopefully hopefully whatever system they're using is at least based on release date, but we never know.
Never know.
All right, guys. I'm RDAP Dan, Federal Prison Time Consulting, with our awesome legal professional here, Tom Roots. If you guys have any questions, please reach out. There's a link in the description of this video. Let me put it here again for those of you that need it. If you're interested in finding out how we might be able to help you shorten your sentence, serve the least amount of time in the best possible situation, I can't stress enough that you go ahead and book a consultation with us. We will make sure we go over all of your questions on a one-on-one level. Here you go, one more time in the room. Take a look at it. It shows you the availability on the calendar. All right, guys, I hope to see you guys soon. Tom, thank you very much. RDAP Dan, Federal Prison Time Consulting, people helping people, communities method, one day at a time. Later, guys.